Hi, everyone. My name is Andrew, and I am recording from a virtual background, which is a picture I actually took of the sunset the evening after I finished the Florida bar exam when I took it in Tampa in February of 2017. So it's a really nice area of the country, and I know it's a stressful time, but my purpose is to simplify all of this and make the Florida bar exam something that we can feel confident we can pass. Today, I'm going to start with Florida contracts, which I believe is an essay subject we would be very pleased to encounter on the exam because there's a solid backbone outline that we can remember word for word and regurgitate on more or less any contracts essay. So I always begin by sharing a little bit of a motivational quote and some information about my business, and then we'll hop right into the lecture. So the motivational quote comes from none other than J-Lo herself. She says, "Don't push your weaknesses, play with your strengths." That's a very important idea. And I learned that in business school too. Make your strengths stronger. Now, of course, we need to shore up our weaknesses. We need to have a foundation so we know maybe commercial paper or family law, which are, subjects that we know more rudimentary, but maybe they're your weaknesses and you just need to know them at the most foundational level. Your strengths, something like contracts, you want to be able to really knock it out of the park because there's a good chance you're going to get this essay. So we're going to play with our strengths and make our strengths even stronger today, beginning with contract law for the Florida bar exam. Also, I wanted to show just a little bit about my business, Ibis Prep. And here's a little review that we got from a student from last July. I used Ibis for bar prep for the July 2021 Florida bar. They have excellent outlines, PowerPoints, and videos available. Also, the crash course live lectures were very useful in identifying my weak points and keeping me focused on what is most important law to know for each subject. Lastly, I did a one-on-one with a tutor where we went line by line on a practice essay, which helped me hone in on my issue spotting and how to better tackle the essays. I ended up passing both sections of Florida bar, and I contribute much of my progress in the last month to the help I received from Ibis. So you can see we really care. And today is actually a celebration. It's a celebration of the last day you're ever going to say Ibis Prep or IBS Prep. The name is Ibis Prep, and the ibis is actually legendary bird. You see here, this bird's doing like the crip walk. And the ibis is the last animal to seek shelter when the hurricane comes and the first to return when the hurricane passes. So locals in Miami know that when the ibis returns, the hurricane has passed. And the ibis turns the hurricane into an opportunity to really prevail in the face of danger by eating up all the worms that have been turned up by the storm. And lastly, Ibis is actually Thoth, who was an ancient god, an Egyptian god of wisdom, the moon, and some other really cool things. So this is Andrew with Ibis Prep. We have an instructor for every subject under the sun, and I'm reporting from the virtual background in Tampa, where many of you will be taking the exam. So today we're going to begin with contracts, and contracts is a very easy subject to master, right? There's a few ways that I'm going to go over it, but importantly, I want to show everyone that's using this drive how great these questionnaires are. We have these questionnaires for every single subject so that you can test yourself, and I have the answers too, but it's better that you provide the answers yourselves, and we'll go over them today. So let's begin with a contracts essay and how we're going to approach it. And for this, I can even stop sharing because they're all the same, right? The first thing that we're going to do is identify, is there a contract? And what is a contract? A contract is an agreement between two or more parties in which there are valid remedies at law. The next thing we're going to identify is what type of contract is it? Is it bilateral or unilateral? Unilateral, accepted by performance. Bilateral is going to necessitate contract formation, offer, acceptance, consideration, no valid defenses. So now that we've considered, is there a valid contract? Is it a bilateral or a unilateral contract? We need to determine what body of law is going to be governing. UCC for the sale of goods, or common law for the sale of land or services. When we think of goods, we think of all things movable. We can also think about the predominant purpose test, meaning if the contract has two different subject matters, a service and a good, then we'll look to whatever predominates the contract to determine whether the UCC or the common law applied. So at the beginning, we can get a lot of points here for identifying certain issues. Is there a contract? Is it bilateral or unilateral? Is it UCC or common law? We also want to recognize at the very beginning, are they merchants? And they'll give you the clear language. If they say Tommy, a photographer, and Jeffrey, a artist, those are most likely merchants who engage in that type of activity in business. So if they're merchants, there's going to be a lot of special rules that apply, and we might as well just dump them out. It is important to note, right? That's a key terminology I like to use. It is important to note that Johnny and Frederick, I forget what name I used, are merchants because there are special rules that apply to merchants. For instance, we can consider the Battle of the Forms provision and the knockout clauses, the knockout rule. The Battle of the Forms provision means an additional term will not be considered a counteroffer unless it materially alters the nature of the contract. That's one rule that will apply, the Battle of the Forms provision. Another is the knockout rule. If there are, different terms, we'll knock them out and use UCC gap fillers to put them in. Another rule that applies to merchants is that there's no consideration necessary for either a modification or a firm offer. Another thing that applies to merchants is the written confirmatory memo rule, whereas an oral agreement that is followed up by a confirmatory memo signed by one party between merchants will establish a contract as an exception to the statute of frauds. So we'll look at all of them, but there's certain rules that I can think of off the top of my head, and we should all know that apply to merchants. So at the beginning of the contracts essay, a contract is a valid agreement between two or more parties in which there are remedies at law, unilateral versus bilateral, UCC versus common law, predominant purpose test, and important to note that they are merchants because these are the rules that apply to merchants. Now, we also want to say distinctions between common law and UCC, including the mirror image test, right, that offer must match the acceptance entirely under the common law, and the perfect tender rule under the UCC, where there has to be an actual perfect tender of the goods delivered. So we want to drop a lot of buzzwords at the beginning: predominant purpose test, mirror image rule, perfect tender rule, merchants, bilateral versus unilateral, perfect start to a contract essay. We get all those points, and that's going to be anytime you see a contract, dump all those points out. The first issue is whether there's a contract. Contract is an agreement between two or more parties in which there are remedies at law. It's necessary to determine if it's bilateral or unilateral. Bilateral requires all the elements of formation, whereas unilateral can be accepted by offer. Maybe consider if it's a newspaper, right? If it's a solicitation, or if it's an actual offer because it's specific in manner of acceptance and these different things. Okay, so at the beginning, we have all these concepts and buzzwords that we've gotten points for. Now we simply go into contract formation: offer, acceptance, consideration, no valid defenses. An offer is a manifestation of intent to be bound by the terms of a contract. An acceptance is similarly a manifestation of an intent to be bound by the terms of the contract. Now, we will consider a meeting of the minds to occur here, mutual assent, and intent to be bound by. These are some key buzzwords in offer and acceptance. Consideration in Florida is a bargain for exchange of legal value, benefit, or detriment. A bargain for exchange of legal benefit or detriment. and then no valid defenses. So offer, acceptance, consideration. And you'll go into each one. Is there an offer? Is there a counter offer? Is there a rejection? What will occur there? Is it a firm offer? Is there consideration necessary? Unless they're merchants, there's no consideration. Look for these elements at the beginning of contract formation. But we can identify offer, acceptance, consideration. Then we'll go into no valid defenses. Defenses are going to start with always statute of frauds. Don't overlook the statute of frauds. We consider my legs: marriage, contracts that cannot be completed in 1 year, contracts for lands, executorship, goods over $500, and suretyships. Now, when we're writing an essay, we need to say issue. The issue is whether the statute of frauds will apply. The statute of frauds applies to certain contracts that must be evidenced in writing and signed by the party to be charged. These contracts include marriage, contracts that cannot be completed with 1 year, contracts for land, executorships, goods over $500, and suretyships. Then you say here, because this is a contract for land, it must be in writing and signed by the party to be charged. However, there's ways to overcome the statute of frauds, right? We'll talk about that. I think of swap, specially manufactured goods, written confirmatory memo, admission in court, promissory estoppel, and partial performance. So the first main defense that we're always going to talk about in contracts essays is statute of frauds. Then after that, we're going to get into mutual mistake and unilateral mistake. Mutual mistake, there was no meeting of the minds, so we can rescind the contract. Unilateral mistake, it depends. If the non-mistaken party should have known of the mistaken party's mistake and failed to tell them and essentially took advantage of them, then it will be voidable on the mistaken party's behalf. If not, then the mistaken party will have to bear the burden of that mistake. So we have statute of frauds, we have mistake, which is going to be unilateral versus mutual. Then we want to go into a lot of other ways we can defend a contract. And it's best if you can just list them all. Come on, let's get through it. So what could they be? Well, I always remember there's a lot of I's. Impossibility, incapacity, intoxication, illusory, impracticality, impossibility, if I already said that, infancy, a lot of I's, right? And then unconscionable. We're going to talk about the difference between some of these things. If it's unconscionable, if it's fraud, duress, misrepresentation, these are some key defenses to contract formation. If it's frustration of purpose, illegal subject matter, right? Try to remember all the different defenses to contracts that could apply. It's the same with every contracts essay though. We begin with contract formation. We begin with all those points at the beginning. What is a contract? Who are the parties? Are they merchants? Merchant rules that apply, unilateral versus bilateral, predominant purpose test, UCC versus common law, perfect tender, mirror image, things like that. Then we get into formation, offer, acceptance, consideration, no defenses. When we talk about defenses, we always talk about the statute of frauds. Always look out for an oral contract and the statute of frauds and ways you can overcome it. Then mistake, mutual, unilateral. Then all the different fraud, duress, misrepresentation, illegality, illusory, incapacity, intoxication, infancy, unconscionability, impracticality, impossibility. I keep saying them multiple times. Frustration of purpose. These are all valid defenses. Then we always want to identify the breach. And was the breach substantial? Was the breach immaterial? Argue both sides. A will argue as a material breach. I will argue as an immaterial breach, right? So formation, all the parts about, is there a contract to begin with? Like, are we even in contract world, UCC or common law, and who are the parties and all that? Then contract formation, offer, acceptance, consideration, no defenses. List all the defenses, consider which ones may apply. Then is there a breach? Is it substantial or unsubstantial? And argue both ways. and then damages. And I find grading students' essays, they always forget to write about damages. We need a strong damages. We need to be strong about damages. So let's think about it. Damages, there's two types: legal relief and equitable relief. Legal relief is monetary. Monetary is either compensatory or punitive. Very rarely punitive damages in contracts. Usually it's going to be compensatory. The main compensatory is expectation, to put the non-breaching party in the position they would have been if the contract had been completed. Then we could have consequential damages, which were foreseeable in light of a breach. We could have incidental damages, which are damages needed to recover for the breach. Maybe nominal, lost profits, lost wages, liquidated damages, which have to be reasonable and are limited to 20% of the contract price in Florida. We could have potentially reliance damages. We could have restitutionary damages. These are, to offset ill-gotten gains. These are all forms of legal relief, monetary relief. Then on the other side, we have equitable relief. Equitable relief is going to include specific performance, such as for land or for art, injunctions, and we can have a TRO, temporary restraining order, for 14 days, and then injunctive relief, where you have to actually show irreparable harm and likelihood to prevail on the merits. So we have specific performance, we have injunctive relief, we have promissory estoppel, we have some R's here: reformation, reforming the contract; rescission, tearing up the contract. We have what's known as a quasi-contract, which is the court enforcing a contract, even though one doesn't really actually exist. So there's a lot of different forms of equitable relief. The main one is going to be specific performance for equitable relief, and the main legal relief is going to be expectation damages. So there you pretty much have the backbone outline that you should have memorized, as well as I do, to write on every single essay. Identify if they're a contract, if they're merchants, if it's UCC or common law, if it's bilateral, if it's unilateral, if we're going to talk about the predominant purpose test, if we're going to talk about the mirror image rule or perfect tender, battle with the forms, knockout rule, all those things at the beginning we just want to get points for. Then offer, acceptance, consideration, define them, identify them, counter offers, maybe consider the mailbox rule or something like that. Offers are effective upon receipt, whereas acceptance is effective upon dispatch. So we're going to have, offer, acceptance, consideration, no valid defenses, memorize them. Statute of frauds being the big one, identify what the statute of frauds is, and then talk about all the others: mistake and fraud, misrepresentation, duress, illegality, illusory, incapacity, intoxication, unconscionability, impracticality, impossibility, frustration of purpose, all these different defenses. And then we're going to get into breach, material, immaterial, and then damages: legal versus equitable, legal, monetary, expectation, consequential, incidental, nominal, lost wages, lost profits, liquidated. My dog is crying. And restitution and reliance damages. And then we can have equitable relief, which is going to be usually specific performance, but can also include injunctions and reformation, rescission, tearing up the contract. It can include a quasi-contract and promissory estoppel. So even then, I was a little bit distracted by my crying dog. I still memorized the entire backbone outline for contracts, and I hope we all can memorize that pretty easily. Now, there's some other subjects that I know is heavily tested on Florida, and I'll tell you exactly what they are, and we can hope to memorize them. The first one I'll talk about will be installment contracts, right? Recognize if this is an installment contract, like they're being paid monthly or they're delivering monthly. Every month they're going to deliver 5 sets. Well, the key to an installment contract is if you don't, if you deliver 3 sets one week and you're supposed to deliver 5 sets, that's usually not going to constitute a material breach, as you'll have an opportunity to cure on a subsequent delivery. So that's one subsidiary topic that I want you to have memorized. Besides just the basic outline, and we're going to go over everything, I want you to have installment contract. Also, option contract. I already kind of talked about this. And, modifications. So options contract, you need consideration unless it's merchants. The firm offer rule is going to be held by merchants for up to 90 days. Modification, again, same rule. You need consideration unless you're a merchant. Another thing that's important is anticipatory repudiation. So if they show that they're unequivocally not going to perform under the contract, then the other party can sue for anticipatory repudiation. Usually you need to send a request for further assurances, which is a written request, and you have 30 days to respond to that. And if they don't respond, then you can either sue then or wait for the actual breach. So look for anticipatory repudiation. Look for parole evidence. We know that parole evidence is going to ban contemporaneous extrinsic evidence that's going to contradict a fully integrated contract. But there's a lot of ways that parole evidence can actually get in. If it's to clarify ambiguous terms, or if it's to show a defect or a mistake, a defect in formation or a mistake. These are ways that we can actually allow parole evidence to get in. Also, if it's to show a condition necessary to the contract. So we have parole evidence, anticipatory repudiation, options contracts, installment contracts, firm offer. Also, non-competes. In Florida, non-competes are presumed reasonable if they're under 6 months, presumed unreasonable if they're over 3 years. Usually we look for, up to 2 years for a non-compete. Non-competes must be reasonable in geographic scope, in time, like in duration, and in subject matter. So look out for a non-compete agreement. I've also seen tested that a non-compete for a patent can be up to 5 years in Florida. Okay, so we have non-competes, anticipatory repudiation, parole evidence, installment contracts, options contracts. Also, again, liquidated damages contracts, liquidated damages clauses. They're disfavored. They need to be reasonable. They're for the purpose of damages would be so difficult to measure in the event that they happened that we are going to have contemplate them in advance. We usually see them in construction contracts, like time is of the essence clauses, and they're usually limited in Florida to 20% of the contract price. So that's another big one. Non-competes, anticipatory repudiation, parole evidence, installment contracts, liquidated damage clauses. Those are some of the other key things we could see. So ultimately, you see how I just rattled all that stuff off about contracts? Not that hard, because it's all the same backbone essay and then some auxiliary issues that we might want to see. When you have a contracts essay, identify each piece, like on a timeline. June 7th, this likely constituted an offer because boom, boom, boom. But first, just try to get all your points. Identify, is it a contract? Who are the parties? Bilateral, unilateral, if there's going to be merchants and rules that apply to merchants, and predominant purpose. And then we get into offer acceptance, consideration, no valid defenses, always statute of frauds, consider, my legs, all the other defenses that we talked about, breach, material or immaterial, damages between, and always write about damages between liquidated and equitable relief. And then thinking about some of the auxiliary issues that I talked about, non-competes, parole evidence, anticipatory repudiation, liquidated damages, and installment contracts. Very, very, very manageable, and I think we'll do great. Now what I'm going to do is, look over see if I missed anything, and look over some of the previous essays and make sure I just do a thorough job with this. But I think if you listen and you're shaking your head and you feel like what I said was valid, then you'll do just fine. So if we look at a Florida specific outline, we can see some of these model outlines that I've made, and these are specifically from Florida essays that were tested and model outlines. So let's see what we got. Formation. The UCC applies if the contract is for the sale of goods. The common law applies in all other circumstances, including a contract for services or land. A valid contract requires offer, acceptance, and consideration. An offer exists if the offerer offers the offeree a deal that signals that acceptance will conclude the deal. An acceptance occurs if the offeree agrees to the terms of the offer and gives the offeree notice of his assent. There must be a meeting of the minds for there to be offer and acceptance. Consideration exists if there's a bargain for exchange and legal detriment, which involves performing in a way that one is not legally required to perform. Under common law, acceptance only exists if the offeree consents to the exact terms of the offerer, also known as the mirror image rule. Under the mirror image rule, if the offeree attempts to change any terms of the offer, there's an effective rejection and counteroffer. Under the UCC, if both parties are merchants, a non-material modification will be considered part of the contract. Under the common law, a modification to a contract must be supported by consideration. The pre-existing duty rule prohibits the modification of any contractual duties which have been agreed to absent consideration because the party is attempting to modify something that he or she is currently obligated to do. An advertisement is generally not considered an offer unless it specifies the essential terms and provides an offeree with the method of acceptance. The statute of frauds requires some contracts to be in writing, signed by the party against whom enforcement is sought. Contracts for land and contracts that cannot be completed with 1 year are both within the statute of frauds. Contracts for lands must adequately identify the parties and the parcel of land to be conveyed. Part performance in a land conveyance requires that the party who seeks to enforce the contract must have engaged in partial performance, which is usually evidenced by possession or payment of the purchase price. Equitable estoppel requires that the party who seeks to enforce the contract show that there was a promise and that the party reasonably relied upon that promise to their detriment. Breach. A breach occurs when one party fails to perform as obligated under the express and implied conditions in the contract. Oh, that's a good thing too about implied and explicit. Anticipatory repudiation occurs when one party demonstrates unequivocally that it will not perform under the contract. In this situation, a non-repudiating party may request assurances and, if reasonably certain that the contract has been repudiated, may sue for breach of contract or suspend performance and wait for the actual breach to occur. The general measure of damage in a contracts case attempts to put the plaintiff in the position he would have been if the contract had been performed. A plaintiff does have a duty to mitigate. Oh, that's a big thing too. Duty to mitigate. Make sure we catch that, which requires that he make a reasonable effort to find similar employment. He does not have to settle for lesser employment or move to a distant location to find employment. Restitution damages are only awarded when a benefit has been bestowed and would unjustly enrich the other party if they are not required to pay for that benefit. A plaintiff cannot receive restitution remedies if they receive expectation damages. Specific performance is awarded when there's a definite and certain contract, an inadequate legal remedy, enforcement of specific performance is feasible for the court, and there's mutuality. The party attempting to avoid specific performance can do so by raising various defenses, such as latches or unclean hands. Those are good things that we didn't talk about yet. Latches or unclean hands. Latches is unreasonable delay, and unclean hands meant that they had a part in the misdeeds. Attempting to enforce an employment contract, which is a contract for personal services, is not feasible for the court. Personal services and employment contracts require individuals to work together in a cooperative environment. It is not feasible for the court to monitor the relationship between the parties. Under the common law doctrine of mutuality, both parties must have been able to request specific performance. However, under the modern theory, the requirement for mutuality is met if one party can sufficiently assure performance. Okay, good. The main thing was the same thing that I said off of just the top of my head. We get all those main points. They just kind of added, for me at least, the big one was you have a duty to mitigate damages. Let's always remember that. And then they talk about latches and unclean hands in this outline. We could see another model outline right here, and I'm very thorough. I want this to be repetitive. Applicable law. Contracts for goods are governed by Article 2 of the UCC. All other contracts are governed by common law. In order to have a valid contract, there must be an offer with clear and definite terms, acceptance, consideration, and no valid defenses to contract. The only essential terms under the UCC are party, subject matter, and quantity. Remember, price is not essential in the UCC. Goods are qualified as movable, tangible objects. As this contract is for bushels of tomatoes, which are movable, tangible, will be governed by the UCC. Merchants. The UCC has special rules to apply for merchants. A merchant is someone who regularly deals with the type of goods that are subject matter of the contract, someone who has special knowledge of such subject matter, or a business person involved in the transaction. Anticipatory repudiation. Anticipatory repudiation is when one party to a contract clearly and unambiguously informs the other that they will not or cannot perform the performance required by the contract. Upon an anticipatory repudiation, the non-repudiating party may either treat the repudiation as a breach and sue immediately, treat the contract as rescinded, suspend performance until the repudiating party indeed performs, or wait and sue until a breach occurs. While under the common law, a time is of the essence clause is not typically enforced as a material breach of contract, unless this has been specified when the contract was formed, the UCC requires perfect tender, which applies to goods, quantity, and time of delivery. The UCC does not allow for substantial performance unless under installment contract. Contract modifications. While under common law, a modification to a contract must be supported by consideration, the UCC only requires good faith to modify the contract. Under the UCC, where a party had a reasonable suspicion that the other party may not perform, they may make a request for further assurance in writing from the other party that they will indeed be able to perform as promised in the contract. Upon receiving a request for assurances, the other party must respond within a reasonable period of time, typically not to exceed 30 days, also in writing, with assurances that they will be able to complete their portion of the agreement. If a party fails to respond to a request for further assurances, the requesting party may treat this failure as anticipatory repudiation and take any of the options discussed above. Revocation or repudiation. This is nice. In the event of an anticipatory repudiation, the breaching party may revoke their repudiation any time before a date of performance agreed upon on the contract provided. The other party has not rescinded the contract already. The other party has not materially changed their position in reliance on the repudiation, and the other party has not already filed suit for breach of contract. A contract becomes unenforceable. So now we talk about impracticality. A contract becomes unenforceable if the subject matter of the contract is destroyed, the performing party dies, the performance becomes illegal. Also, if the performance becomes impractical due to an unforeseen occurrence, the non-occurrence of which was essential assumption of the contract that makes performance impracticable and was not the fault of the other party. Impossibility of performance will only be excused if it is not objectively possible to perform. So remember, there's impracticality, it's impractical. Impossibility, it's impossible. And frustration of purpose, the purpose has been frustrated. I know that's, not the best definitions, but I could explain them in detail, but they are what they are. Okay, compensatory damages. Compensatory damages are damages meant to put the non-breaching party in the position they would be in if the contract had been performed. Typically, those are determined by the difference of the market price and that of the contract, or the difference between the price of the goods purchased and the non-breaching party's attempt to cover and the contract price. So cover is another concept we talk about here. A party only needs to be put in an objectively reasonable effort in finding a reasonably priced product to cover. Compensatory damages are damages. Oh, we talked about that already. Consequential damages. So this right here, we could talk about expectation damages too as the main measure of consequential damages. Consequential damages are any damage that arise naturally out of the breach of contract that are not compensatory. These damages are actually caused by the breach, but for the breach, these damages not have been suffered. And the main one, foreseeable and relatively certain as the amount. And then incidental are damages suffered by the non-breaching party in trying to remedy the breach. And then reliance damages. Reliance damages are recoverable as the cost suffered by the party upon reliance of the contract and reliance that the other party would perform. Reliance damages and compensatory damages cannot be both obtained, as such a party must choose between reliance and compensatory damages. And then again, duty to mitigate. A non-breaching party must do all that is reasonably possible to mitigate damages and eliminate costs. The damages recoverable will be reduced by what has actually been mitigated or what could have should the non-breaching party fail to take steps. All right, excellent. So I have two outlines here that I made from a different state, from California actually, but it's pretty nice. These two are about remedies, and I'll just go over them quickly because in California, remedies is tested separately In Florida, it damages will be part of a contracts question. So these are great outlines. Rescission is an equitable remedy under which a court will invalidate a contract in its entirety, such that the parties to the contract are completely excused from continued performance under the contract. Generally, rescission is available when one party has a valid defense to the formation of the contract. Moreover, typically only the wrong party can seek rescission. Because rescission is an equitable remedy, a court has broad discretion in describing whether it should be awarded. The court will award the equities of the situation, taking into account the fairness of rescission to both parties. In addition, as an equitable remedy, rescission is subject to equitable defenses such as acquiescence, estoppel, laches, and unclean hands. So laches, I'll go back to them. The defense applies where a claimant unreasonably delays in bringing suit and where the suit prejudices the plaintiff. The doctrine of acquiescence applies where the plaintiff has previously acquiesced to similar conduct on the part of the defendant for which the plaintiff is now seeking relief. That's good, acquiescence. Unclean hands is an equitable defense where available where the plaintiff has engaged in some wrongful and inequitable conduct with respect to the same underlying transaction for which the plaintiff is seeking relief. And estoppel is an equitable defense available where a defendant reasonably, foreseeably, and detrimentally relied on a plaintiff's statement that the plaintiff's conduct is permissible and where it is equitable to enforce that promise. Fraud misrepresentation. A contract may be invalid on the basis of fraud, where a party made a false statement of past or present fact. This statement was either fraudulent or material to the contract, and the other party relied on the statement or of fact in entering into that contract. So look for fraud misrepresentation for sure. Under the doctrine of mutual mistake, a contract may be invalidated where both parties are mistaken about a material fact, that is, a fact that was a basic assumption of the contract. Under the doctrine of unilateral mistake, a contract may be invalidated where one party is mistaken about a material fact underlying the contract and the other party knows or has reason to know about that mistake. Like rescission, reformation is also an equitable remedy. However, under the doctrine of reformation, a court will not invalidate the contract in its entirety, but rather will rewrite the contract to conform to the party's original intent. Moreover, like rescission, reformation is typically only available to the wrong party. Again, because reformation is an equitable remedy, a court has broad discretion in describing whether it should be awarded, taking into account all of the equities. Reformation, too, is subject to equitable defenses, such as acquiescence, estoppel, laches, and unclean hands. So from this sheet, we definitely learned about the equitable defenses. The parole evidence rule, which generally holds where a contract is integrated and intended by the parties to be a final agreement, a party may not admit evidence of a prior agreement that is inconsistent with the contract's terms. However, there's an exception to the parole evidence rule where a party seeking to provide evidence of a mistake or clerical errors in reducing the contract to writing. Good document. Here we talk about TRO. A TRO is an order granted in equity that preserves status quo until a preliminary hearing on matters that can be heard. They're generally granted in emergency situations. Okay. And then TROs are 14 days in Florida, and then we'll have the preliminary injunction. Preliminary injunction, you have irreparable injury, balance of hardships, likely to prevail on the merits, and there has to be a notice and a hearing. And then finally, specific performance. In contracts, specific performance is a remedy in which the court orders a defendant to perform his obligations under the contract, usually only available for unique goods and for real estate transactions. In order for the court to grant specific performance, the following elements must be met: valid contract with clear and definite terms, inadequate legal remedy, feasibility of enforcement, mutuality of performance, and no defenses. All right, excellent. So let's see some other Florida essays that we've done. This is from February 2020, and I've done the outline for you. Employment contracts. Generally, employment is considered at will unless there's an enforcement employment contract. A contract is an agreement formed following an offer, acceptance of the offer, and consideration. The statute of frauds requires that certain contracts must be in writing and signed by the party to be charged to be enforceable. This includes agreements that cannot be contemplated within 1 year. A court will not award specific performance in contracts for services. This is because specific performance for services is difficult to enforce and may be considered involuntary servitude, which is unconstitutional. Even where the services are unique or to be formed by a person with unique skills or talents, the court will not award specific performance for the reason described above. So here, where it talks about an employment contract, salary is actually an important piece of a employment contract. You do need salary. Okay, damages. Generally, a non-breaching party to an enforceable contract is entitled to compensatory damages. Where possible, a non-breaching party can recover expectation damages, which are intended to put the non-breaching party in the position she would have been had the contract been fully performed. And then consequential damages are those damages arising out of the breach that are reasonably foreseeable at the time of the contract that the breaching party should have known were reasonably foreseeable as a result of the breach, including business losses. Although restrictions on an individual's ability to be employed are disfavored, non-compete clauses are enforceable. So it's non-compete, at least to a limited degree. They will be closely scrutinized and will be enforced only if they protect a legitimate business interest, is no more restrictive than necessary to protect that interest, and is sufficiently limited in scope and duration. Absent a showing of unique circumstances, courts will not enforce non-compete clauses for more than 2 years. In Florida, there's a presumption that non-compete clauses for a duration of less than 6 months are reasonable, and non-compete clauses of more than 3 years are not enforceable. All right, that was all we had for contracts there. So remember, employment contracts, non-competes could definitely be tested. Did we look at this one yet? No, not yet. A contract is an agreement or set of promises enforceable by law. For there to be a valid contract, there must be mutual assent, which is a valid offer and acceptance of clear terms. Both parties to be bound by, supported by consideration, no valid offenses. An offer may be accepted by the manner indicated in the offer by any reasonable manner. Performance is by implication. Conduct is an acceptance. Under the common law, the mirror image rule requires that an acceptance match the offer exactly. Any changes are deemed a rejection and a counteroffer. Under the UCC, amended terms are only accepted if they are merchants and do not materially change the offer, or the offer is not expressly conditional to acceptance of its terms, or the offer does not object within 10 days. Consideration is a bargain for exchange for something of legal value or detriment to one party to the benefit of the other. The UCC covers the sale of goods, which are tangible movable property. Statute of frauds applies to sale of goods that are more than $500. If it's mixed goods, the service is applicable. We will provide the predominant purpose. A contract specified beyond 1 year and cannot be performed in less than 1 year will be subject to the statute of frauds. A writing can be in more than one document as long as it's clear it is referring to the essential terms of the agreement, and the signature can be by any method that indicates the party sought to be bound, such as a company seal or letterhead. Mutual mistake. When there's a mutual ambiguity or mutual mistake that goes to an essential element of the agreement and both parties were unaware of the ambiguity or mistake, the agreement may be rescinded and each party shall be entitled to claim in restitution anything they gave of value. If one of the parties is aware of the ambiguity or mistake and the other party is not, the contract may be enforced in favor of the party that was not aware of the ambiguity or mistake. And then contracts that limit a party's ability to compete are valid as long as signed by both parties and are reasonable as to the geographic scope, subject matter, and time limits. Limitations on patents are deemed reasonable if the limit is 5 years or less. This is a rebuttable presumption. An employee may be required to give ownership of IP to an employer during employment if developed for employer during the scope of employment. Parole evidence is evidence of oral agreements prior contemporaneous with the agreement that are usually not permitted in the written agreement if it's fully integrated, a full expression of the agreement. However, it is allowed in the common law if there's an ambiguity or the agreement is not fully integrated, or to supplement the agreement as long as it does not materially contradict the terms of the agreement. And the plaintiff can bring in extrinsic evidence to clarify the scope of a patent obligation and what was meant for cause. Finally, we talk about accord and satisfaction. When there's a dispute as to a debt, a party that offers a lower amount in satisfaction of the debt and rights paid in full fully performs and is discharged. So the accord is the agreement that's going to replace the contract, and the satisfaction is evidence that that has been satisfied. A delegation is duties. You're delegating duties. An assignment is rights. You're assigning rights. And a novation is an actual substitution of the parties. An assignment and delegation will not relieve the original party from privity. Okay. I think that might be all of them we have here except this one, right? Uno más. Yeah. Okay. To be enforceable, a contract must have offered acceptance consideration of our defenses and acceptance of manifestation of intent to contract on the terms of the offer. Consideration must be a legal benefit to a party, legal detriment to the other, bargain for exchange, statute of frauds. We talked about this. In addition, Courts will generally not preclude a proper modification of a contract based on writing only clause where the parties manifest the intent to subsequently change the contract and the modification is properly effected. The statute of frauds and the writing only clause would not bar modification of the party's contract. Parole evidence, however, is only prohibited to contradict or supplement integrated contract or prior writings or prior contemporaneous oral agreements. Evidence of conditions precedent, mistake, or subsequent modifications may be considered when necessary. Under the common law, contract modifications must be separate consideration. A pre-existing duty to perform is not adequate consideration to support a contract modification. In contrast, under the UCC, a good faith modification suffices without consideration. Generally, a contractor must complete his project without additional compensation if the partially completed structure is destroyed through no fault of either party. The defense of impossibility is considered on an objective basis or whether the party can reasonably perform. To allege impracticality, he would have to show that an unforeseen event, the non-occurrence of which was a presumption of the parties materially altered his performance to such an extent that performance is excused. A contract generally needs to contain all essential terms, including identification of the parties, the price, the manner of the payment, the obligations, and be signed by the party to be charged. Now, this price thing is different. If it's real property, then yes, not always. If it's UCC, they'll supplement a price. Provisions regarding insurance or the failure to obtain insurance will likely not render a contract unenforceable. Generally, a unilateral error by one party does not stand as a hindrance to contract formation. However, when one party knows or should have known of the error, he will not be able to snap up the benefit of the mistaken agreement. Where the parties did not enter into a binding contract, an aggrieved party may obtain relief based on promissory estoppel or detrimental reliance. To prevail on detrimental reliance, the injured party must show a promise from the breaching party that was intended to create reliance, justifiable reliance on that promise, and that injustice will occur if the injured party is not awarded damages. Compensatory damages are awarded to a non-breaching party to put them in a position they would have been absent of breach. Compensatory and expectation damages include incidental and consequential, liquidated where appropriate. Punitive damages are generally not awarded in contracts. And when a non-breaching party reasonably covers, as is his duty, he will be entitled to the difference between the contract price and the cover price, plus any incidental or consequential damages. All right, that was super excellent. We went through all these outlines. Rules and distinctions. Let's see if we have any distinctions. A promise to pay debt barred by the statute of limitations is enforceable if it's in writing and signed by the party to be charged. So that's, consideration for a previously barred defense. Marriage of a minor removes contractual incapacity, notwithstanding that subsequent death of spouse or dissolution of marriage. Marriage of a minor removes contractual. So if you're married in Florida, then you can't say that you're don't have contractual capacity. Let's see if there's anything we missed from this outline. Governing law, predominant purpose test, common law over UCC, offer, acceptance, counteroffer. I accept, but I will not pay more than $750. This creates the ability of offer to accept or reject the counteroffer and is not about acceptance under common law. Revocation, an offer is generally revocable until it's accepted. Until accepted, we have the exception, which is the firm offer rule, governed by the UCC, where a merchant promises to keep an offer open for a specific period of time without consideration. As in specific language, it will remain open for up to 90 days. If they're a merchant in writing, they give assurances that will remain open, signed by the offeror. Options contract, irrevocable promise to keep the offer open for a certain period of time in exchange for valuable consideration. Unilateral versus bilateral, void, voidable, unenforceable. Void never had any legal effect. Voidable is voidable by one party, and unenforceable means there's a formation-related defect to an otherwise valid contract. Perfect tender rule, UCC requires, modification. A contract may only be modified with consideration under common law, but under the UCC, no additional consideration is necessary. Perfect tender, you must have perfect tender. Non-conforming goods would be a breach, and the remedies for the buyer are accept the goods and sue for damages, or reject some or all the goods and sue for damages. Opportunity to cure, the seller gives the buyer notice and delivers conforming goods, or the seller has reason to believe the non-conforming goods would be accepted by the buyer. Talked about the statute of frauds, parole evidence rule, complete negation, murder clause. What's not barred by the parole evidence? Agreements executed after the execution of the contract, oral agreements made after the execution of the contract, evidence determined there was a mistake, evidence concerning defense of a party based on misrepresentation, fraud, or duress, and evidence used to clear up ambiguities in the contract. So some defenses: illegality, look for an illegal subject matter or purpose. Illegal subject matter is not enforceable. Legal subject matter but illegal purpose. Contract is only enforceable by one who did not know about its legal purpose. Misrepresentation, false assertions, concealment, or misstatements about a material fact before the contract to make it voidable. Duress, maybe in the form of economic or physical duress, that's going to be a threat, which is voidable. Unconscionability. Courts may refuse to enforce all of a part of a contract if either procedurally unconscionable, unfair surprise, a new material term, or oppressive terms, substantially unconscionable, which are often hidden. Mutual mistake of fact. If both parties are mistaken about a fact, it's void. If both parties are mistaken, the mistake concerns a basic assumption of fact. The mistake materially affects the agreed upon exchange, and adversely affected party did not bear the risk of the mistake. Unilateral mistake, only one party is mistaken concerning underlying facts of the agreement. Unilateral mistake will not prevent contract formation. Warranties, express warranty, when the seller promises or describes facts about the product's usage, the express warranty will be breached if the product fails to perform as they promised or described. And then a merchant selling good automatically warrants that the goods are fit for its ordinary purpose. That's applied warranty of merchantability and fitness for a particular purpose from torts. Damages, expectation, consequential, liquidated, duty to mitigate, we talked about, specific performance as an equitable remedy, rescission, mutual cancellation, modification, consideration for common law, no consideration with UCC with good faith, and then accord, satisfaction, novation, delegation. Accord and satisfaction, parties agree that satisfaction in accord is a condition for fulfillment of the original contract obligations. Novation, parties mutually agree to substitute a new party to perform, and the original party is excused from performance as no further obligations under the contract. And delegation, one party may delegate its obligations under the contract to a third party without the other party's consent. However, the delegation does not excuse the delegator's liability on the contract. Super dope. We have model outlines, rules and distinctions. These are complete outlines, which are mostly for the MBE, but it's the same. You know, if you want to look at all the deep details, you can watch our MBE video or look through this outline. And then the last thing I'll show you all, well, last two things is, one, this questionnaire. And we have these questionnaires filled out, or you can fill them out yourself, but making sure that we left no stone unturned, right? And what I'll actually do is pull up one of my students who I know did it well to just make sure that we have something to look at. So for student accountability folders, I'll pull up Ben. I'll pull up different questionnaires from different students for different subjects. All right, let's just look at his with the answers. What's the definition of a contract? Legal enforcing agreement between two parties in which there are equitable remedies at law. What type of contracts? UCC versus common law, UCC goods, common law land and services. Definition of goods are all things movable. Unilateral versus bilateral. Unilateral is acceptance by performance. Bilateral offer, acceptance, consideration. Mutual assent, meeting the minds for an offer. When can advertisement constitute an offer? If it's sufficiently definite in its terms, communicated to a specific person or persons, and the advertisement clearly shows the advertiser has the intent to enter in the contract. Acceptance, consideration, rules for merchants, no consideration necessary for modification, 30-day rule for anticipatory repudiation, firm offer rule, no consideration necessary, battle of the forms. If both parties are merchants, the court will ensure that the final agreement contains the terms and conditions that match both parties' forms. Any terms that do not match are eliminated, and any terms that are added in the acceptance but are not material are also part of the agreement. That's the key. Risk of loss. So shipment contract. If goods sold by a merchant are not shipped by a common carrier, the risk of loss passes to a buyer when the buyer takes physical possession of the goods. However, if they are shipped by a common carrier, the UCC provides for two types of agreement. Shipment contract requires that the seller place the goods into the possession of the carrier. A destination contract requires that the seller deliver the goods to the buyer at a certain location. If a shipment contract is used, then the risk of loss passes to the buyer when the goods are delivered to the buyer. If a destination contract is used, the risk of loss passes to the buyer when the goods arrive. Accommodation, no contract is formed, offer instead. So if you ship with a letter of accommodation, it's not a contract, it's an offer. Even if, I won't get too deep into that. Okay, predominant purpose test we talked about. Mirror image rule, battle of the forms, he just mentioned, perfect tender we talked about, statute of frauds. What can overcome statute of frauds? Swap, specifically manufactured goods, written confirmatory memo, admission in court, performance, promissory estoppel. We talked about mutual and unilateral mistake, the difference being it's void. We can void it if it's mutual. If it's unilateral, it depends if one person was being taken advantage of. He has some great defenses: misrepresentation and fraud, illegality, illusory. Illusory means that there was no real language to make a contract. I will do it when I feel like it. Right? You pay me $50 and I'll tutor you when I feel like it. That's illusory because you're probably never going to feel like it. All right, duress, undue influence, incapacity, impossibility, impracticality, frustration of purpose, unconscionability. If one or more contractual provisions are overreaching on behalf of one party, gain unjust and undeserved advantage, it would be unequitable and difficult to enforce them. Material and immaterial. Material breach affects the heart of the agreement. This happens when one of the contract parties fails to do the very thing that the contract was created in the first place. Non-material breach, when the failure to perform was a minor one, the purpose of the contract is still intact, and the party substantially performed according to the terms of the agreement. Equitable and legal relief. Legal is monetary. Equitable is, court ordered. Legal, expectation, consequential, incidental, liquidated, reliance, lost process, lost wages, restitution, unjust enrichment. Equitable, specific performance, injunction, reformation, promissory estoppel, rescission. Quasi-contract. Quasi-contract refers to a situation in which a defendant is bound as if there were a contract, even though no formal contract exists. When a party sues for damages under quasi-contract, the remedy is typically restitution or recovery under a theory of quantum merit. Solid word. Non-compete, reasonable in duration, scope, subject matter, 6 months reasonable, 3 years unreasonable, patents 5 years. Options contract, a contract that offers the buyer to sell the underlying asset if they desire. Requirements is a contract for a supplier, manufacturer, and a purchaser where the seller requires to provide the requirement with all the goods that the purchaser needs, so all they require. Where output is, I agree to produce, I agree to buy all that you produce. Requirements is, I'll produce all that you require, and output is, I'll buy all that you produce. Installment, like we talked about, series of installments. Non-conforming shipment likely is afforded the opportunity to cure. Firm offer rule under the UCC, up to 90 days that they'll hold an offer open. No need for consideration. The mailbox rule. Offer upon receipt, acceptances upon dispatch. Liquidated damages, 20% of contract placed in Florida. Hard to define losses, specified sum in the contract. Anticipatory repudiation, parole evidence, we talked about these over and over again, and that's about it. So that's the questionnaire. You should have that definitely memorized. And then the last thing that I'll show you all today is what we can expect on test day. And I hope this was really thorough, and we're all feeling pretty confident that if we are to get contracts as an essay subject, we can really crush it because easy to memorize all the different things and to recite them on test day. So here you can see we have all the official essays and model answers, and we'll just take a peek at some of them and how they're presented and what you should be looking to write about. A lot of tabs. I was about to make a joke, but my humor sometimes is well intended, not well received. Okay, so this one, classic. I can just look at it and see this is a non-compete. This is a guy doing a radio show. So they want us to write a memo. We always look at, call the question first. Prepare a memo evaluating the claims that they could assert against Rodney or WWF, and the claims that WL could assert against Rodney and WWF, and Jack could assert against Rodney, and the remedies. Always remember remedies. I might even write damages first so we don't run out of time. Now, here I would set it up as W Law versus Rodney. W Law versus WDF. Jack versus Rodney. 4 remedies for WD Law. 5 remedies for Jack. I would structure my answer exactly how they ask it. And then we just make sure we're going to hit all these points. What is a contract? Offer, acceptance, consideration, no valid defenses, breach, material breach. And then we're clearly going to go into some non-compete agreements. And I see the word alcohol. So there's going to be some incapacity, voidable issues. What do they talk about? Breach of contract, employment contract. A contract is an agreement followed by offer, acceptance, consideration. Here we have all these things. Statute of frauds applies. When does it apply for all these different terms? See the same thing. Specific performance would be involuntary servitude. So we're not going to be able to get specific performance. A non-breaching party to be enforceable is entitled to compensatory damages, expectation damages, ameliorating the breach. So we're talking there about your duty to mitigate damages, consequential damages they talk about and they define, non-compete and what it's enforceable by. Remember, scope, duration, and subject matter, 6 months, 3 years, non-enforceable. That was it. And then there was a tort question after that. You know, they did a pretty good job. I would have even done better about defining what is a contract and how we can get some points for that. Let's take a peek at 2004, see what we were looking at. Remember, it's not always going to be an entire part of the essay, but it's going to be important. So here you have an offer, different things. What's the call to question? Claims against them and potential defenses, and then ethical issues. So I would do claims, defenses, issues. And I'd set it up as a memo, to, from, read, date. Jump right into it. We're issue spotting. I guarantee we're going to spot, is there an offer? There must be offer, acceptance, consideration. He goes through acceptance and all these different things. He talks about options contract, talks about the mailbox rule. He talks about consideration, talks about she's a minor, statute of frauds, detrimental reliance, option, anticipatory repudiation, and then talks about what they'll argue, damages, specific performance, and then, you know, a short discussion. I'm a big fan of IRAC, issue, rule, analysis, conclusion. We see, though, there's not too much that we are going to get in a contracts question that is going to be super surprising. See what's going on in 2016. Year I graduated law school. It was a good year for me. What's the call of the question? Memo analyzing claims, defenses, and outcomes. Valid contract. What's a contract? Contract formation, consideration, statute of frauds, offer and acceptance. Talking about statute of frauds here. Agreement was ambiguous, mutual mistake or unilateral mistake. Non-competes. Now this one talks about the patents being 5 years. I hope you learned that from the parole evidence they talk about. See above regarding contract formation issues. Never repeat rules. You're not going to get any more points. But then you talk about ways to accept under the common law, the mirror image rule. You know, this is where they're getting all their points. Under the UCC, we talk about if they do not materially change the offer. And then this one talks about an accord and satisfaction. Contract modification requires consideration. Covenant not to compete. Right, you still have to do a new IRAC if it's a new claim, but you don't have to write the rule over again. You're not going to get points for rewriting the rule. All right, let's look at one more. I haven't seen anything too new. Let's see what happened in 2018. So contracts and ethics. We have an investment advisor. Discuss the possible claims, the elements of the claims and defenses, where they can return any fees and ethical issues. So breach of contract, promissory estoppel, restitution. Breach of contract, offer, acceptance, consideration, and they talk about it here. Few defenses, unilateral mistake, illegality, statute of frauds, always statute of frauds. Predominant purpose test or UCC versus common law, modification, common law, new consideration, modifications they talk about. Make sure you feel comfortable with modifications. Expectation damages. And then promissory estoppel. This is good. Under the promissory estoppel, The defendant made a representation. The plaintiff reasonably, foreseeably, and detrimentally relied on representation, and they will enforce the representation to the extent necessary to prevent injustice. Promissory estoppel, and then restitution. Restitution claims involve showing the plaintiff conferred a benefit. The benefit was not gratuitous or officious. The defendant had an opportunity to reject it but did not. Pretty solid. So restitution and promissory estoppel. Restitution, same elements as described above. Okay, restitution, promissory estoppel. Make sure that you take it, feel comfortable with them. Let's just look at 2005, see if it's a little bit more normal, because those two issues, restitution, promissory estoppel, you know, they're equitable defenses that we don't see too often. Here, 17-year-old student. Okay, we're already going to talk about her being underage. We have a contract, offer, acceptance, consideration, no valid defenses, statute of frauds, whether she's a minority, anticipatory repudiation, we see a lot, breach of contract, detrimental reliance, so promissory estoppel we see again. That's the detrimental reliance, promissory estoppel. Let's make sure we got that. Material versus immaterial breach. Impracticality as a solid defense. I like that. Impossibility as a solid defense. Whether it's a divisible contract. So you can argue for the divisibility of contracts. I like that. This contract is divisible. And then expectation damages. So, a lot to absorb, a lot to digest, I guess. But my point of contracts is that it's relatively simple. They all start off the exact same way, right? Always, is there a contract, offer, acceptance, consideration? What are the defenses? We're always going to talk about statute of frauds. What type of breach is it? And then the issues that we see coming up. Oh, and damages, always damages. And then the issues we see coming up are common: anticipatory repudiation, parole evidence, non-compete agreements, right? So make sure you understand this detrimental reliance, promissory estoppel, and the other one that we saw was restitution for the ill-gotten gains. Those are two forms of equitable relief, but otherwise, I was not surprised by what we've seen in these essays. Very, very procedural. You go through them all the same: offer, acceptance, consideration, no valid defenses, what type of breach is it, and then look at all the different remedies, and then just consider where you can get other points. But I feel like this was a very thorough start to the course, and some of the other topics will be a lot shorter, but I wanted to be thorough with contracts so that we heard everything and that we could feel really comfortable and happy to get a contracts essay on test day. So thank you all so much for joining me, and I'm sure I'll see you back for some of the other subjects. And have an amazing day, and best of luck on your exam.